Really the last time that L-1 was reformed by Congress. Hello and welcome to another episode of Visa Vibes. I'm Emily Newman, managing partner at Reddy Newman Brown, and with me today is my partner Stephen Brown. Together we help businesses, professionals, and families navigate the complex and ever-changing landscape of U.S. immigration law, particularly for businesses or employment-based immigration.
Hey, Emily, thanks for, leading us off today. So today, kind of continuing as we start this podcast with some of the employment-based visa basics. So today we're going to talk about L-1 visa, probably the second most common work visa behind H-1B. This is for intercompany transferees where there's a foreign office abroad and a U.S. office. We're going to talk about what that is. It's not just any foreign office and U.S. office. There's a lot of strict requirements on this from USCIS, and that was, going back to the first Trump administration, the Obama administration, the Biden administration wasn't less strict, especially when we talk about L-1Bs. And we see a lot of, we're going to talk about the key differences between the two types. L-1 has two subtypes, L-1A and L-1B. New office Ls for companies that are abroad wanting to get into the U.S. Market, and some of the recent trends and how L-1 fits into the green card process. So just kind of another, visa basics today.
Yeah, so the L-1 is definitely a great pathway for bringing global talent into the U.S., but it has very strict requirements. There are a couple of different ways to go about getting an L-1 versus an individual filing or a blanket filing, not like the warm and fuzzy cozy blanket that you wrap around you. So we'll talk a little bit about that, but kind of where did this visa come from? How long have we had it? What did it start with? So back in 1970, it was created to basically help these multinational large corporations be able to transfer employees into the U.S. for their operations. So it was really designed to encourage foreign investment and foreign company expansion into the U.S. And make it easier for them to bring that expertise that they need from an established and existing company to help build a U.S. office. But it is also used by smaller companies as well. You don't need to be a huge global entity to make this work. We've definitely see more and more scrutiny of L-1 petition filings. It has a pretty high rate of requests for evidence. So we'll talk about what the issues are. One other thing with the L-1 that is unusual is that spouses are able to work.
Yep.
And they don't need a separate employment authorization application anymore, thanks to some litigation that you were involved in. You want to give us a little background of that?
Yeah, so, when the L-1 visa was created, the Congress also included L-2 spouses and children, just like they do for H-4, and most visa categories allow for dependents. But E-visas and L-visas, and we'll focus on L today, had specific requirements that having that status entitles them to work authorization. We call it work authorization incident to status, meaning I have this status, I'm entitled to work authorization. And for years, decades, USCIS was, okay, yeah, you have work authorization, but you have to file an I-765 and get the employment authorization document. And when we're talking about people who've just transferred in, that could be months of waiting. When we started this litigation, a year, right, of waiting. And so we had sued, among other things, about that this should be work authorization incident to status, because that's what the statute says. And, USCIS agreed that is what the statute says, and reframed their policy around that.
All right. Another area of the L-1 is that blanket that I mentioned. So it's a kind of a separate program that was created later on in 1990. And it's meant to be for those large companies. You have to have at least 3 domestic and foreign entities all over the globe. And then you also have to have either $25 million in U.S. sales, a U.S. workforce of 1,000 employees or more, or at least 10 L-1 approvals in the last 1 year. I would say since 1990, they haven't changed those requirements. So it's kind of 25 million is a somewhat low threshold now.
Yeah.
Maybe that needs to be looked at for updating, because definitely small companies are small-ish companies. I mean, 25 million is not anything to sneeze at, but in the grand scheme of things, there are more and more companies are qualifying for this blanket program, which streamlines the process. We'll explain how it works in a little bit, but I don't think that was necessarily what it was intended for. I think it was meant for the huge companies.
Yeah, maybe when that was written, 25 million is a lot different in 1990 than here we are, 35 years later. So it could be, one of the things that we see change, modernize. We talk about that quite a bit, of modernizing our system, and some of it's just numbers need to change.
Yeah. And really the last time that L-1 was reformed by Congress was 2004. So 21 years ago, They decided that there was a concern that companies were using L-1 specialized knowledge workers to basically staff them at U.S. companies, allowing U.S. companies to eliminate their U.S. workers, potentially pay lower salaries because the entities from outside the U.S. were paying lower salaries, and there is no salary requirement with an L1. It does get taken into account because obviously if we're saying this person is an executive, a manager, or specialized knowledge, they're likely to have a high salary, but there's no set minimum on that. There's no prevailing wage for it. So there was definitely concern that companies were using the L1 to bypass H-1B requirements and potentially displace U.S. workers. And so that Visa Reform Act of 2004 was meant to restrict what we call third-party placement. Basically, you can't be staffing someone to a third-party site doing this specialized knowledge work. There's got to be a supervisor on site where you're actually implementing a specific project or something like that.
Yeah, and you mentioned the wages. H-1B, we have specific wages that are set, prevailing wages, but also one of the interesting parts of L1 is that it allows these international companies to have more free-flowing transfers. And, H-1B has the lottery, right? Mm-hmm. That's in March. It's coming up here in a few weeks. And then it's an October 1st start date. And so you really got to plan out from March. Hope I get selected. Hope I get this person selected to start in October. L1, you can file an L1 tomorrow.
Yeah. Yeah, so what are the general requirements for a company to qualify for an L1? Number one, there has to be a company outside the U.S., and they have to have a company inside the U.S. or be getting ready to set up a company inside the U.S. And those two companies need to have the correct qualifying relationship. So that's typically going to be like a parent and subsidiary, where maybe the foreign company owns and controls the U.S. entity, or the other way around. The U.S. entity owns and controls the foreign entity. So that's kind of one option. There can also be branch offices where it's one entity, but they have multiple branches around the world. Or it can be an affiliate relationship or sister companies where there's one parent company, and that parent company majority owns and controls both of the company abroad and the company in the U.S. It could be maybe through a holding company. You can even have joint ventures as long as there's clear operational control. So there's lots of different ways to do it, but you have to look at really the ownership of all of the entities to make sure they have that correct relationship. And then once the person is coming into the U.S., the foreign company still needs to operate. Right. So if you're thinking of, I'm going to send my executive from my company abroad to set up a new business and operate it in the U.S., and my foreign company is going to go away because he's the only executive there, that won't work. The foreign company has to continue operations as well. So you mentioned there's two different subcategories, L1A and L1B. What are those, and what's the difference?
Yeah, so L1A is executives and managers. L1B is specialized knowledge workers, and they're very distinct in both how the law is written and what you have to prove up and the benefit, right, that you get. So L1A are executives and managers, and it's not just I'm a manager, or I'm the CEO of the company, right? They want to see, when we're talking about executive level, that they have that high discretion, high level decision making. They're influencing the policy. They're setting the policy. They're supervising managers and more senior level employees. And for the managers, again, it's not just, well, I'm the manager, I do this. They got to supervise professional employees that are underneath them, or they direct a key function that is an essential function of the business. We call it a functional manager. But USCIS does a lot of digging on this. They're not going to take the title alone, and they're going to want to see, are you directing these employees? Are you doing their timesheets? Are you doing their performance reviews? And then are you offloading what they call your non-qualified job duties, right? So you have to be primarily functioning as a manager. Emily runs our firm, but I don't know. I don't know if you'd qualify as an L1A manager because you spend a lot of time, doing immigration work, not just managing the firm. And that's what they want to see, is that the majority of your time is management, not doing the work. And that really might be counterintuitive to how a lot of businesses actually work, but it's how, the law is written. So L1A has a validity of up to 7 years. You can do, for the most part, 3 years at a time. So 3, 1. And if you were doing what's called a new office L1, you only get a 1 year L1 that first time, and then you could do the 3 extensions, kind of the opposite. And we'll talk about new offices, L's in a minute. And L1A is nice because it has a twin sister, green card, EB1C. EB1C is for managers and executives. So like the L1A, you have that qualifying relationship between the U.S. and foreign entity. You're doing a managerial job abroad. You're doing a managerial executive job in the U.S. EB1C allows you to file it without doing the labor certification because, again, it's that twin sister of the L1A.
All right. Now, specialized knowledge is, so one other thing I want to mention is for any employee to qualify for this, they have to have worked for the foreign company for at least 1 year in the last 3 years in that manager, executive, or specialized knowledge capacity. Now, just because someone worked for 1 year doesn't necessarily mean they have specialized knowledge. So they have a set definition of what specialized knowledge is and how you can prove it, and it's either special knowledge or advanced knowledge. Super helpful.
Yeah, like very easy to understand.
Wording here, but so special has to be distinct or uncommon compared to other workers in the industry. Advanced means greatly developed or further along in progress, complexity, and understanding compared to other workers in the company. So either way, we're having to compare this applicant, this visa applicant, to other workers to show that they are their knowledge is distinct or uncommon, or it's more complex, more further along in complexity and progress. All this boils down to you really need that deep expert level understanding of what's going on in the company, the operations, the processes, the procedures, the methodologies, the research. There's a long list of things. Is this person's knowledge something that's not easily found in the labor market, especially in the United States? Because we're basically bringing them here because they have that special knowledge, and we can't find a U.S. worker, or it would take too long to train a U.S. worker in the same level of expertise, and the company might lose out on business or not get contracts, that sort of thing. So that's why we need to bring this person in.
Yeah, and whenever I talk to companies, because you mentioned that it's circular, right? It's, it's this very abstract concept, and what I always break it down to is, why is this individual so important that there's no one else that can do this job? They're the only person that can do it, and we've got to bring them over, or else we're just not going to be able to do what we want to do. And that's kind of the way you have to think about it. And I know a lot of immigrants, and it's doing this, they don't like to brag on themselves. They're very humble about what they do. And I tell them, no, you've got to brag. Like, I am the best at XYZ that exists, and here's why. And here's how I became that best XYZ to qualify.
Yeah, we literally have to put together a chart many times of the specific knowledge that this person has compared to other people in their organization doing similar jobs, to show that this person is more knowledgeable than other people. With the L1B, it can be granted for a total of only 5 years. So the L1A is 7, L1B is only 5. And it doesn't have that same path to a green card that EB1C is not an option for someone who was specialized knowledge abroad. Now, there are some funny tricks to it because you can intermix between specialized knowledge, manager, or executive. So you could be specialized knowledge abroad and be coming to the U.S. to be a manager. Great for L1A, doesn't work for EB1C,
right,
even though you're a multinational manager. But if you were a manager abroad or an executive abroad and now coming into the U.S. to be specialized knowledge, you're L1B, even though you were a manager abroad, not specialized knowledge.
Yeah.
But if you are later promoted into a managerial or executive role in the U.S., you can convert from L1B to L1A, and now you're eligible for EB1C. Could you make it any more complicated?
Yeah, it's that chart, you always see the gif of it, the guy kind of going crazy with all the red lines and but it does work. I mean, I just filed someone who is a manager by title, but doesn't really meet L1A, and we filed it as specialized knowledge. It's okay.
All right. Now, we mentioned the blanket earlier and how larger companies can qualify for that. What's the benefit of having the blanket? What's the process like for individuals, and then what's the process like for blankets?
Yeah, so when we file an individual petition, we've got to file with USCIS. You pay the high filing fees. You put it together. They're going to send you an RFE because they don't understand any of it, and they like to send RFEs, on L1s, especially if it's an L1B. And then you got to respond to it. And you got to submit evidence of the qualifying relationship, the share certificates, the organizational structure, memorandums of understanding, association, whatever it might have been, the company formation documents that show the qualifying relationship and show that both the U.S. and the foreign entity are doing business. And then you show, why they're specialized knowledge or manager, and then evidence to support that, and that they worked 1 year abroad. Okay, so you put all that together, do an I-129, do the L supplement, send it to USCIS. That's the individual. If you have what's called a blanket, and Emily mentioned, you have that petition that's approved, you can get it eventually. I think it's 2 or 3 years initially, and then it's indefinite. You get this blanket that says, here's all of our organizations, right, in our corporate umbrella. And you could go right to the consulate, right, for a blanket filing. You put together a packet. You still need to talk about how they're a manager or executive, but you're not going to put together the same amount of evidence. You can put in some references to things, but you're not going to put together a giant stack like you will with USCIS. And they could go right to the consulate. So it saves on filing fees. It saves on time, because you don't have to go through USCIS, then to the consulate. You just go to the consulate, and then they make the determination. If you're Canadian, right, both of these can be done right at the port of entry. But the blanket, if you qualify, is a quicker, more efficient, more cost-effective path forward as long as everybody qualifies.
All right. Now, we talked a little bit about how the L1 can be used for companies expanding into the U.S. So that's considered to be a new office L. So if your U.S. company operations have been in existence for less than 1 year, you're automatically considered to be a new office. And that has some special rules, more documentation required, a little more difficult to get approved. And you only get an approval for 1 year.
Yep.
After that 1 year, now when you're filing your extension, especially for managers or executives who are meant to come here and kind of set up the company and get it off the ground and up and running, after that 1 year, you've got to prove that your company in the U.S. has grown to such a level that it will now support a manager or executive position. So if you've hired no employees over the last year, or don't have any contracts or very little revenue, you could get that first year approved and then get denied your next extension because the business didn't grow fast enough. With the new Office L, they are looking at what is the viability of the company and what is the likelihood of job creation here. Main thing, you have to show that you have sufficient space leased or owned, but you have to have an actual office space to house the workers that you're intending to bring over. And usually you need a business plan, and it's got to be a pretty detailed, sufficient one to show what it is you're going to do, how you're going to be making money, how you're going to support these workers and ensure that they get paid. And then they want to see wire transfers, what money has been sent into the U.S. to set up this U.S. company, and what steps have you taken? Do you have that lease agreement? Do you have your bank account open? Do you have your tax ID number? Do you have your website built? Do you have your internet set up? Do you have a phone plan? All those sorts of things are with the new Office L. And there's a lot of scrutiny of those, but even more on the first extension that you're trying to file.
Yeah, this is something that they are going to do a deep dig. There is a case out there, Matter of Ho, that talks about the business plan requirements that you have to go to, really kind of broadly for immigration benefits that require a business plan. But there's a lot of scrutiny in this. It's not just, oh yeah, you have the money, you're going to get this, you know. But it is one of the few paths we have for companies to bring business into the U.S. without already kind of having a footprint.
Yeah, and especially if you're not from a treaty country that
Right.
has the e-visa option. E-visas are somewhat similar to L's, but it's only available for certain countries. So if you don't have that country, L is your only option. So what are we seeing in terms of requests for evidence, denials? Like, what are the trends going on right now? What do you think is going to happen under the Trump administration?
It's a good question. I can't tell day to day what's going to happen the next day. You know, we have seen a historic scrutiny on L-1B, and I think a lot of the issues with L-1 stem from the fact that unlike H-1B, where there's all these regulations and there's all these policies and there's all these things that have interpreted what the statute means, and so everybody kind of knows what rules to play by. That isn't the same with L1, especially with L1B. And so it's kind of the Wild West for both adjudicators and practitioners, where you don't really have as much supervisory documents for the adjudicators. You kind of have to, they're going to ask a lot of questions, because we talked about this, you know, in the middle, that it's a very abstract concept about specialized or advanced knowledge. And so what really is that? And they're going to question it. You know, we see RFEs on ensuring there's a qualifying relationship. Sometimes they don't understand, you know, what's going on. Sometimes that pops up. And then what happened abroad and what's going to happen in the U.S. That, you know, most RFEs for an L1 are foreign job, proposed job, right? And they want to make sure it qualifies, and just, you know, maybe they don't even look at the evidence sometimes, but a lot of questions, especially with L1B. L1A, a little bit cleaner, because the statute does talk more about managerial capacity and executive capacity. It's kind of got those, the regulation kind of gives some better definitions, I think, than L1B. But L1B is a lot more broad.
All right, and now if someone is coming in on an L1A or an L1B, obviously they only have 5 years or 7 years maximum. Now we look at the green card process, which, as you mentioned, L1A does have kind of that path to a green card under the EB1C category. They skip the labor certification requirement, go directly to filing an I-140 petition. So it's considered to be a fast track green card, but maybe not so much, because even the EB1 category has backlogs now, particularly for people that were born in India or China. And the L1B is a little tougher because there is no direct path. You have to go through the usual employment-based path that everyone else goes through, which is perm labor certification, proving that the company couldn't find a qualified, willing, able, available U.S. worker in that location for that particular job, and then waiting for a green card to become available, which these are going to fall under the EB2 or EB3 categories, which all have cutoff dates. They're all backlogged. So you have a real issue now of people that are maxing out of their L1 time, definitely L1B, because if you're from India or China and there's a 100-year wait for a green card and you only have a 5-year visa, you don't have any option. And there's no extending beyond that 5 or 7 year limit other than recapturing time you spent outside the U.S. or switching from L1B into L1A that buys you an extra 2 years. But even for L1As with that fast track green card in the EB1C category, 7 years might not be long enough to be able to get the green card before your time maxes out. So you might be stuck with leaving the country after 5 or 7 years, waiting outside for 1 year working abroad, and then coming back and resetting the clock for 5 or 7 years. Or what's the other alternative?
This is, you know, it's funny you mentioned this. I had a meeting with some employees from a company last week who just are here on L1A now, and we're starting the EB1C process, but they see what the visa bulletin says. It's stuck in 2022 for Indian nationals. Like, I don't know if that's going to move forward in the next 7 years. And they're looking at the H-1B lottery, and it, shouldn't have to. If we were a sane immigration system, 7 years should be plenty of time. But outside of leaving for a year, you could go through the H-1B lottery, get your H-1B approved, and then, with the I-140 that you're going to get approved, you can do the AC-21 extensions beyond the 6-year limit, as long as you have it maxed out already. So, the conversation that we had is, well, I max out in, 6 more years. When should I try it? And the thought is now. Because we don't know, and we talked about this, in one of our earlier episodes about the odds for the H-1B lottery. They want to maximize their opportunity to not have to leave the company here in the U.S.
All right, so as we've been doing, we want to wrap up with some common myths and misconceptions about this particular visa category. So myth number 1 is really any company can file an L1 petition. It's easy to get.
Yeah, hear that. A lot of people think that, I know there's an office abroad. We've got ABC Inc. abroad, and we've got ABC Inc. in the U.S. Let's do it. Let's do an L1. No, it's, you have to have a legitimate ongoing qualifying relationship, and just because you have the same name does not mean you have a qualifying relationship. Y'all may operate kind of together, but it's very detail oriented and very clear on what the government needs to show that qualifying relationship. And it's, again, have to have that U.S. and foreign entity.
All right, now how about myth number 2? The L1A works for pretty much any supervisor. Like, it's not hard to prove you're a manager or executive.
They are very detail-oriented on this. The rumor that when we started wanting to talk about this was that I know L1A managers that all they do is collect timesheets. That's all they do. That's not going to get you an L1A. It is legitimate manager. You are directing employees. You're telling them what to do. You are evaluating them. You're approving their time off. You're working as that manager, or if you're a functional manager, you're overseeing and have discretion over an essential function of the business. And that's...
Yeah, and you've got to be doing that a majority of the time.
Right.
So as you mentioned, I wouldn't even qualify, even though I am the managing attorney, managing partner here. I do all of those things that you said, but it's not the majority of my time. Majority of my time is doing the work of being an immigration attorney. So I wouldn't qualify. What about L1B? So I've worked for the company for 1 year. That's all that is needed, right? I just have to prove I worked for the company for 1 year.
Now, like I said, this is excuse my language, I've described it to clients that I've gotten close with it. Why is this person Billy Badass, right? They are the best at what they do.
I was afraid of what you were going to say.
No, a little better than that, but they are the best at what they do. And I'm trying to bring them in to do XYZ job, and they are the best person in our entity. I've got to bring them to the U.S. We have these goals. We're going to bring them in. And it's not just they have the industry standard. That's not just I could go hire someone else to do it. They are the guy or gal to do this job.
All right. And then once I get an L1, I can work for any company. Once I'm here, I can transfer it to another company.
No, yeah. So unlike H-1B, you get H-1B, you can, have that flexibility, not with L, because you have that requirement of you have to work with the foreign entity for 1 year within the last 3 years in order to qualify. You can't just transfer. So if you got laid off from your L1B employer tomorrow, you can't just go across the street to the next employer and have them transfer for you like you could on an H-1B, not the next day, but go through a process. That doesn't exist for L1.
All right. And then the L1 automatically leads to a green card. Is that true?
No. And again, we have paths, right? L1A has that twin sister because the analytical facts, I call it a twin because the legal analysis is very similar. There's a little minor tweaks here, but they're very similar for L1A to EB1C. L1B's got to go through the perm, both of them backlogged for, China and India. Perm-based green cards are backlogged for everybody. And it's, again, have to petition. You got to prove it up again. So even if you have an L1A and you're going to an EB1C, you've got to prove it all up again. So it's not just oh yeah, I have an L1A, give me my green card.
Yeah, I feel like the L1 standard, the EB1 standard is a little bit higher than an L1, especially if you're coming from the consulate. Yeah. Which is funny because when you're coming from the consulate under a blanket L, the standard of evidence is clear and convincing, whereas USCIS is preponderant.
Yeah, so more than 50%.
Yeah, so there's a difference there, but it's almost easier to get a visa under the blanket at the consulate than it is with USCIS, even though the standard is actually higher at the consulate. So just one of the many unusual, tricky, not common sense things that immigration has. But the L1 is a great option for multinational companies. It's got a lot of twists and turns in it. It is easier than an H-1B in terms of there's no limit, there's no cap on them, there's no prevailing wage requirement, but you do have to have that 1 year of employment abroad with the company in either a manager, executive, or specialized knowledge capacity before you can qualify. The company has to have that qualifying relationship. If you're filing with USCIS, the scrutiny is definitely high. We definitely see a lot of requests for evidence, and that's definitely going to continue under the Trump administration. So if you're thinking about an L1, or maybe your company is interested in that process, you definitely want to start early. It does require a lot of documentation to be gathered, and definitely work with an attorney on that. So that's all we've got for today. Thanks so much for joining us. We hope you will subscribe to Visa Vibes on either Apple Podcasts or Spotify or on our YouTube channel so that you can always get the latest of our podcast episodes every week. And if you have any suggestions or things that you'd like us to talk about, let us know.
Yeah.